I salute you all. Thank you for listening and thanks for watching. So basically today we are going to look at types of mortgages basically. And we have legal and equitable or informal mortgage. Those are the two types of mortgages that we have. The legal mortgages, the equitable stroke informal. It is equitable or informal basically types of mortgages. So basically under this essence, we are going to look at the legal mortgage. As you hear the word legal mortgage most of the law rotating around it, first of all, is the RTA. RTA confirms that the person that is carrying, actually, the mortgager, the mortgager is the registered proprietor of that what? Of that particular land. You get? So note that in mind. We have a mortgagee and a mortgager. A mortgagee is the person that they have mortgaged land to. A mortgager is the person that is mortgaging his or her land. You get? In regard to get that financial assistance. You get? The principles, as earlier have seen the earlier video, that a mortgage is only a mortgage once security is on what? Land. And what is meant by land? Use the knowledge that you have under fixtures and chattel. Fixtures and chattel, that gives you an element that anything attached on land becomes part of land. So don't feel confused that if someone mortgages a house, you may think that it is not a mortgage. It is land. The house is land. Lawyers can relate. So basically that's the essence. First of all, we have a legal mortgage. And the legal mortgage, basically, concerning the Black's Law Dictionary, the Black's Law Dictionary defines it as a creditor's mortgage arising by operation of what? Operation of law as the debtor's what? Property. That's concerning the Black's Law Dictionary, and this is also authentic that lawyers will use such dictionaries. Then when you read section 2, subsection 1 of the Mortgages Act, provides that any person holding land under any tenure can mortgage his or her interests in a prescribed form in that particular act. What do we mean? Actually, in the prescribed form, it is under the second schedule of the Mortgage Regulation Act. You get the second schedule, which defines that the requirement is signature and attestation. The formation of a mortgage has two elements basically. That is signature and attestation. Basically, as we are going to see, that where you don't attestate on the mortgage, where you don't sign, where the mortgagee and the mortgager don't sign, that mortgage deed is invalid and it's void. So basically note that in mind. And remember, they say that even failure to sign, it is a fatal what? Defect on the mortgage deed. You get? For example, we see that when you read under section 131, provides for attestation of the RTA, and section 132 provide for signature, whereby the signature must be in a Latin character. You get, as you shall see. So basically failure, this was portrayed in the case of Diana Nancy Kombi Bossa versus Stanbic Bank Uganda, and later also affirmed in the case of Alice Okrol and another versus Global Capital Savings. Basically, they held that in both cases, they held that where a mortgage deed is not signed or is not executed in a form that is provided under section 131 and section 132, that mortgage deed is invalid. You get? And basically they also lament that it is a requirement that a mortgage deed needs attestation. Attestation, what do I mean by attestation? Provided under section 131, basically attestation, where there's a famous case under mortgages, the case of Frederick Zabwe versus Orient Bank Uganda. Here they show that the rationale for attestation and signature being in Latin character, it is set out in the view that it shows that the parties had to consent and it was by their free will, basically. You get? And it shows that basically signing must have capacity. That is unimplied. That for you to be a witness, for you to sign on such deeds, you have capacity. Capacity will mean that you must not be a minor. must not be of unsound what? Unsound mind. Those are implied elements that follow, though we shall not highlight them. So basically that is the need. And they held that the non-compliance with provisions portrayed in section 131, section 132 of the RTA, that is Registration of Titles Act, was given in the case of General Parts Uganda Limited versus non-performing assets recovery trust, where the court stated that the effect of a mortgage being invalid is that it is absolutely illegal, and any transaction to it is null and what? And void, which cannot even be sanctioned by the what? By the courts of law. Basically, in that essence, is null and what? And void. You get? So basically that gives you that those elements are key under forming a what? A mortgage deed. Most so we are under a legal what? A legal mortgage, basically. And we realize that the issue of where there is where a registered proprietor is to give powers of attorney. Powers of attorney are provided under section 130 of the Registration of Titles Act. Powers of attorney. Where someone gives powers of attorney, any person that acting under those powers must state that I'm signing this deed on behalf of so and so, following the powers of attorney provided by him under section 130 of the RTA. You get? When the deed, where basically the powers of attorney are not portrayed, that the person signed following the powers of attorney that was given on him, the mortgage is null and what? The mortgage deed is null and what? And void. Still, the case of Frederick Zabwe versus Orient Bank, the court held that the reason as to why the person that has been given powers of attorney must make it clear to the registrar is that there's where court lament says that how would the registrar, by just a mere looking at the mortgage deed, know that the second respondent had authority at this property if it is not expressed? So how? You get? That is the question. Which means the second respondent in this case, when he's acting under powers of attorney, you get, he must issue a document clearly stating that he signed the deed on behalf of the registered what? Proprietor. You get? And when you read also under legal mortgage, when you read section 2, subsection 4 of the Mortgage Act, provides that a legal mortgage only takes effect when registered. We shall correlate with it with section 54 that provides that no instrument shall take effect unless what? Registered. And a mortgage deed shall be registered as an encumbrance on the page of encumbrances on the certificate of title. You get? Let me hope we are all at key. On the page of what? Encumbrances. On the certificate of what? Of title. Basically, that is a legal mortgage. Then we go to the equitable mortgage or informal mortgage. An equitable mortgage or informal mortgage. Basically, as you hear the word equitable, this deals more so on unregistered land, basically. Unregistered land, this is land that basically you are holding it under unequitable interest. You are not the registered proprietor. It may be unregistered customary land. You get? So that is deals with. The law provides that you can also mortgage the what? That land. Unequitable marriage is a transaction that has the intent but not the form of a mortgage, and that the courts use equity to treat it as a what? As a mortgage. You get? So basically that is the essence there. The courts use equity to treat it what? As a mortgage. But it just has the intent, but doesn't have a form of what? Of a mortgage. There is an unequitable maxim that says that equity ought what to be done to be done. Basically, it ought what to be done to be done. There is that equitable maxim. It is the one that applies here. You get? In this essence, such agreement that follows in that category is an equitable agreement and is an equitable mortgage. You get? We have the case, it is a complicated case. We have the case of Bingi, Bhimji, and another versus Gyan Singh Bamba. Gyan Singh is Gian, Singh is Singh, Bamba is Bhamba, and others. Basically, under this case, court provided that it is established that an equitable mortgage is duly created when the transaction has intent, but not the form of what? Of a mortgage. So long as the intention was to create what? A mortgage. The courts will apply the doctrines of equity and the doctrines of common law to make it a mortgage, basically. And when we read section 1 of the Mortgage Act, defines an informal mortgage. Remember, this is an equitable stroke informal mortgage. Section 1 of the Mortgage Act defines an informal mortgage to mean a written and witnessed undertaking. A written and witnessed undertaking, the clear intention of which is to charge the mortgager's land with the repayment of money or money's worth obtained from the mortgagee, and it includes an equitable mortgage and a mortgage on unregistered customary land, basically. So that's how the Mortgage Act defines what an informal mortgage means. An informal mortgage has three elements that are crucial. One of it, there must be a written undertaking agreement. That's one of it, for it to be existing. A written undertaking agreement. Secondly, in such undertaking, the mortgager intended to charge his or her land as security. You get? That is two. Thirdly, such land acts as security for repayment. Those are the three elements that must be witnessed so that they claim that under equity, the mortgage what? Existed. You get? So basically, and this gives the authority that when you read still under section 2, subsection 1 of the Mortgage Act, confers powers on any person holding land under any tenure to mortgage his or her interest in land by an instrument in the prescribed what? In the prescribed form, basically. Note that in mind, in the prescribed form. And under this equitable and informal mortgage, there must also be a mortgage deed, which must be attested and witnessed. It must be attested and signed. Attested provided under section 131 of the Registration of Titles Act. And the signature and signed, that is section 132 of the Registration of Titles what? Titles Act. You get? And such equitable interest, when you read section 29, when you read, first refer to this, refer to Article 237, Clause 8 of the Constitution that talks about customary land, something like that, of equitable, that is equitable. Then you read section 29 of the Land Act that talks about the lawful and bona fide occupants. All these have equitable interest, but still they can mortgage their property. You get? And basically, note that in mind. Then we have, actually, they can mortgage after seeking permission from the registered proprietor. You get? Then we have the case of Commercial Microfinance Limited versus Edgar Kayondo. Under this case, the issue was the determination whether the defendant could take unregistered land as security. Then court relied on section 2 of the Microfinance Deposit Taking Institutions Act that provided that, of course, where there is a customary certificate of ownership provided under section 8 of the Land Act, in particular, basically, certificate of ownership of customary land, that certificate can be referred to and used to get a mortgage. But the doctrines of equity and common law are the ones that apply here, basically. And when you go further under informal mortgages were further emphasized under section 2, subsection 8. Section 2, subsection 8, whereby someone to get, which allows that a borrower and the lender to enter into an informal mortgage. The person permits the accepts the following things: the certificate of customary ownership, certificate of title issued in the RTA, the lease agreement, among others. Read section 3, section 2, subsection what? Subsection 8, basically, in that essence. So, meanwhile, also generally, to continue under the informal equitable mortgage. In this essence, we have this element that the case of granted, G-U-A-R-A-N-T-Y, granted discount company limited versus credit tenants corporation limited and another. Basically, where it was observed that it is not necessary that a note should accompany the deposit of such instrument. But however, to avoid controversy in the interest of both parties, there should be a memo setting out the objects of the deposit and the terms of the same. Basically, when you read that case tentatively, you get. And still under informal or under unequitable mortgage, where two or more persons registered as proprietor, still, actually, this is an element under mortgages, where the property is owned by more than one proprietor. In this essence, we are giving an example of what? Of the two people. You get. Both of them must consent, and both of them must be there at the time of depositing that document, the lease agreement. Let it be a title, let it be a certificate of customary. Both of them must be there. Where one person is not available, or one person doesn't consent, that mortgage deed is what? Is null and void, basically. So this gives you an essence that both must agree. You get. Both of them must agree. We have the case of De Souza Figueiredo. De Souza Figueiredo versus Talot and other. Basically, here, where two executors were registered as proprietor of the suit property, only one deposited the certificate on the security for a loan. The court held that the deposit of the certificate was ineffective to create an equitable mortgage. You get, because one of the executors was not what? Was not around. You get. Even under mortgaging of a matrimonial home, provided under section 4 under the Mortgage Act. Matrimonial home, before going further, section 1 of the Mortgage Act defines what a matrimonial home means: a building or part of any building in which a husband and wife, or any case, or wives and their children ordinarily reside what? Reside together. Basically, that is a matrimonial home. You can also explain it in any language that is easier for you. Then when you go to section 2, subsection 1 and subsection 2, permits a person claiming an estate or interest in a part of the four tenure systems to mortgage the same by even creating third-party mortgages, second, subsequent, and suits, and the sub-mortgages, basically. When you go to subsection 3 of section 2, also to the effect that the right should be exercised subject to any prohibition or limitation imposed by this what? By this act, which is the Mortgage what? Act. So basically that gives an element. And in this essence, what we look at, or what we prove, is that under a mortgage, you get mortgaging of a matrimonial home, section 40 makes a limitation that someone cannot mortgage a property without the consent of a spouse. Read section 40 of the Land Act. Basically, section 40 of the Land Act. Someone cannot mortgage a property without consent of the what? Without consent of the spouse. You get. So you have the case of a need to muevas versus Impereire, Stephens, and other. the court emphasizes that the provisions of Section 40 of the Land Act on spousal consent are mandatory and must be considered. You get? And also the case of Alice O'Croll and another versus Global Capital Save and another still emphasizes the same. You get on that. They fall under unequitable mortgage in this essence. You get? So basically, that is the things that I can talk about under a legal mortgage and unequitable mortgage. In this essence, what we are looking at or what we are trying to prove is that we have two categories, legal, then informal, stroke, equitable mortgages. But other than that, thank you for listening and be on, comment where you feel necessary. Good luck.